Welcome to Rebel Chaser. My name is Gail, and I have a video for you from Judge Wolf, and this one is a little bit of a different one. So I don't want to say much about it. I'll talk to you at the end. I'll just let you guys watch this.
Your Honor, we're here on a motion to dismiss that was filed by Ms. Sunny Stevens on behalf of Elizabeth Walker. We're ready to proceed.
Stevens, your motion to dismiss, is that correct?
Yes, Judge. But also, Judge, I don't remember if I filed the case law, and I don't know if Ms. Williams has a copy of that, but I have a copy. I'm not sure if Your Honor has it. I don't recall if I filed that or not. I believe I did, Judge. But if not, I have a copy of that for everyone.
Well, the file contains a copy of your motion to dismiss, in which I think there is case law cited, but I don't believe that there is.
Yes, Judge, and I briefed it all. And I believe that was filed, Your Honor, the brief, but perhaps the law was not. Well, Judge, as you know, Mr. Walker, he filed for divorce July 23rd, 2023. On March 13th, 2024, you granted an interlocutory order granting the divorce, but at that time, the property had not been divided. Mr. Walker died on May 24th, 2024, and that was before we had any final property division that was made, and there was no final order entered prior to his death. On May 24th, 2024, counsel for plaintiff filed a suggestion of death. And on August 29th, 2024, an agreed order was entered to substitute the descendant's estate as plaintiff in the matter with the issues pertaining to marital property division. A Rule 5402, which I'll read it for the record, Your Honor, but when more than one claim for relief is present in action, whether it's a claim, counterclaim, cross-claim, or third-party claim, or when multiple parties are involved, the court, whether at law or in equity, may direct the entry of final judgment as to one or more, but fewer than all the claims or parties, only upon express determination that there is no just reason for delay and upon the express direction for the entry of judgment. In the absence of such determination and direction, any order or other order, form of decision, however designated, that adjudicates fewer than all the claims or the rights and liabilities of fewer than all the parties shall not terminate the action as to any of the claims or parties, and the order or other form of decision is subject to revision at any time before the entry of judgment, adjudicating all claims and rights and liabilities to all parties. Additionally, Rule 3, Tennessee Rules of Appellate Procedure provides that any order that adjudicates fewer than all the claims or rights and liabilities of fewer than all the parties is not enforceable or appealable and is subject to revision at any time before entry of the final judgment, adjudicating all the claims, rights, and liabilities of the parties. So what we are saying, Judge, that the order awarding the husband a divorce was not final and was subject to revision at any time prior to the entry of the final order adjudicating all the claims. In the case that's cited, McMahon versus Butler, Court of Appeals of Tennessee, which is, I think, on point and almost mirrors the facts of our case. And that's the case that we have today before you, Judge, that our parties wanted a divorce, you granted a divorce. The divorce was granted subject to the final property distribution. Unfortunately, plaintiff died, so that was never done. So what we believe, and what I believe the Tennessee Court of Appeals found, the death of the husband in that case terminated the action for the divorce, and it must be dismissed. And the court reasoned that there was only an order declaring the parties divorced, but as Your Honor knows, the property settlement agreement or the final order was not determined in our case, and also in this case that I'm referencing. So the order declaring the parties divorced was nothing more than an interlocutory order and not the final order. So based on that, we're asking the court to dismiss the order. And on page 2 of what's being cited, Judge, at the very bottom, the court noted, however, that this is not the situation here. As you read through the case, the wife had not agreed to division of the property. In fact, the property rights of the parties were being litigated, and the final decision on the aspect of the case had not been made. Under those circumstances, we think the death of the husband terminated the action, setting aside all preliminary orders and terminating the power of the trial court to make any further orders on the case. And that's what we're basing our motion on this morning, Judge. And again, this was also briefed. It's very, very brief, a few pages long, in addition to the case law that's been provided.
And your client wanted a divorce, correct?
She did, Your Honor.
You
She did
filed-
want the divorce.
You filed an answer and a counterclaim seeking a divorce.
The divorce, but not the division of the property. As Your Honor may recall, the day that you did grant the divorce, I had that objection that he testified that he was in ill health. He didn't know how long he was going to make it, and the property was still undivided at that time.
And what disadvantage to your client is there by sustaining the granting of the divorce? How is your client prejudiced by the granting of this divorce?
Well, Your Honor, the other party isn't here to determine what is marital property. When my client left, there was an order of protection. She literally had the clothes on her back and a pocketbook, a purse. She still has personal items, 20 plus years of pictures, photos, clothes. She's been enjoined from going to the home. Now there's a probate matter that's been opened, so everything is subject to the substitution of counsel coming in place of the decedent. So what is going to be marital property and private?
You had filed a motion to substitute the estate for Mr. Walker based upon his death, correct?
Yes, Judge.
Right. So if you're seeking to have the estate substituted for the decedent, then it would seem to me that that's a position that says, I want the estate to be involved in it so that we can litigate these issues, is it not?
Yes, Your Honor, but that was prior to finding this case law that's spot on to what we have now, that according to the Tennessee Supreme Court terminates any power of the trial court to make any further orders in the case. So that's why we would ask that based on that it be dismissed and follow according to what McMahon and Butler has already set aside.
And for example, the property that was owned by him prior to his death, or prior to the marriage, the real property that was owned, by dismissing this case and rendering the granting of the divorce moot, so to speak, it would obviously be to your client's advantage because then she would be an heir to the estate, being his wife, and would have the right to inherit at least a 1/3, if not more, correct?
Absolutely, Judge.
And that would be more advantageous to your client than having to have a litigation where the issue would be whether or not she had actually contributed to the increase in value or preservation of that.
Well, Your Honor, despite that, the Supreme Court says, it says it right here, Judge, that under those circumstances, the death of the husband terminated the action setting aside all preliminary orders, which was the interlocutory order that I'm arguing.
Stevens, what the Court of Appeals decision says, I'm just asking for questions on the record about the reason why your client wants to set this aside is because it's much more advantageous to her to have an estate rather than the divorce action.
No, Judge, I don't think it's more advantageous. I think it's the law. I think it's what it states here, and that's why we're arguing it. Is it advantageous? Perhaps, perhaps not, but that's just what the appeals court determined in this case, and that's what we're arguing, Judge.
Anything else?
No, Your Honor, thank you.
Hey, Your Honor, if I could, just from here, if that's okay, I think the microphone is on. Your Honor will remember this case was filed, and we had a substantive hearing before Your Honor on the 22nd day of January, wherein proof was presented. Discovery was taken in this case. And again, Your Honor made a finding at that point in time that based upon the sworn testimony of the respondent, that being Mrs. Walker, her answers found in sworn discovery responses and the finding of the court of the plaintiff's current medical condition necessitates that the court award a judgment on the pleadings and grant an absolute divorce to the plaintiff on the grounds of inappropriate marital conduct of the defendant, and hereby restores both parties to all rights and privileges of unmarried persons. The issue of division of assets and other related matters is reserved pending a final hearing in this matter. Your Honor specifically will recall that Mrs. Walker, the life of Mr. Walker, that he fell, she left him for dead, and was effectively trying to kill him so she would inherit from him. That's what the proof showed.
this is argument. I'm not accepting what she's saying as fact. I'm just accepting it as argument.
Well, Your Honor, and again, that's what the proof showed, what Mr. Walker testified to. Mrs. Walker admitted in her discovery. The case that was presented is very distinguishable in the fact that the husband in this case withdrew in the case that was cited in the McMahon versus Butler case. The husband withdrew his complaint for divorce, and the wife proceeded only on her complaint. The husband had no pleadings before the court, and at the hearing he withdrew his complaint. Mr. Walker was seeking a complaint, was seeking the divorce, and there was an admission on her behalf, on Mrs. Walker's behalf. And Your Honor found an order of protection was necessary in this case, extended the order of protection that had previously been issued in this court, and found that she was a credible to Mr. Walker. Mr. Walker did die after the fact, and the issue of division of assets is reserved. A suggestion was filed before this court, and the estate was substituted as a party. And Your Honor, what's interesting to note is that under section 30, under 36, section 1, grounds for divorce are separate from the division of assets provision under the law. Is again, the in personam jurisdiction of the divorce itself was met prior to the death of Mr. Walker. And what's unique in the respect is that originally there was a motion to set aside the judgment of the court that was filed with this court. I did send Rule 11 safe harbor letter to counsel based on the filing of that motion to set aside. She struck the motion to set aside the order and then substituted it with this motion to dismiss. And of course, I didn't have 21 days notice, so I would have, if I had had 21 days notice, I would have filed another safe harbor letter and asked that it be dismissed. But Your Honor, the fact is that the grounds for divorce is separate from division of assets. Specifically, the grounds for divorce cannot be used to alter. The statute clearly states that grounds do not affect the division of assets. And so Your Honor specifically reserved that issue. And I think this case, again, as I said, it's distinguishable. And there's a number of things in this. Again, counsel handed it to me 2 minutes before, and I'm aware of this case, but the fact is that each case is unique. This court has the authority, based on the circumstances, to grant a divorce prior to the division of assets. And this case is one that is paramount to that because Mr. Walker was the victim of domestic violence. And that heightens the level of that he needed to be protected from the defendant. And now the defendant comes before this court already admitting that she was a credible harm to her now deceased, to Mr. Walker, and seeks to set that aside and financially benefit from her own ill treatment. And again, the specific finding of the court was to protect Mr. Walker. He was frail. He was terminal at the time. And this was all before the court in January of this year when the court was granting the divorce. And I think it's a unique set of circumstances. And again, it doesn't apply. This case does not apply because the unique set of circumstances in this Walker case was you were doing it for the protection of the plaintiff, Mr. Walker, due to the ill treatment and the credible harm of Mrs. Walker to him. And again, the issue of division of assets is still there. And again, they have filed in the estate case. Mrs. Walker has filed a claim in the estate case. But she cannot be treated as his spouse. Because again, the order was entered. She could have taken an interlocutory appeal from that order. She did not. She filed a motion to set aside, abandoned that. And again, the unique set of circumstances in there and the finding within the statute that there's no corollary, there's nothing in Title 36 that requires this court to reserve the issue of granting of a divorce until a property division is made.
Stevens?
From what I'm hearing, it sounds like an order of protection is now a divorce decree. There was an order of protection in place prohibiting my client from going to the marital residence. It sounds like that Ms. Jennifer's using the divorce decree as a protective order for her deceased client, which is not the case. The divorce was granted. I objected based on his testimony that he was terminally ill and could die at any moment. And I said, Judge, it's going to put my client in a really tough position in the event that he does die and we don't get to the property division. A few months later, Mr. Walker passed, and that's where we are today. And again, going back to this Tennessee Supreme Court ruling, the interlocutory
It's
rule.
actually a Court of Appeals ruling.
Thank you, Judge. The trial judge awarding the wife in a divorce was not a final judgment and subject to the revision at any time because there was still property that needed to be divided. That's where we are. I don't know how this is unique and different and separate. I read it. I mean, minds see things differently, but the black and white letter is exactly where we are today, subject to revision at any time prior to the entry of an order which adjudicated all the claims. There are still claims outstanding, Judge. Property division. That is an outstanding claim. And then going back to that last paragraph, the wife had not agreed to the division of the property. The fact the property rights of the parties were being litigated, which we are still doing today, and the final decision on that aspect of the case had not been made. Under those circumstances, we think the death of the husband, Mr. Walker, in our situation, terminated the action setting aside all preliminary orders, the divorce, and terminating the power of the trial judge to make any further orders in the case. I believe that's where we are here today, Your Honor, based on our set of facts and circumstances almost mirror this. And that's what we're asking for today. It's not going to put anybody in a different, better position. It's just the way that it's written. That's my argument, Judge. This is what I'm arguing, that we did want the divorce, but not under those circumstances. And the day we did object, and you asked me, Ms. Stevens, does your client want to be divorced? Yes, well then, so it is, and that's how it was. But I protested because he testified terminally ill. The order was in place prohibiting my client from engaging with him. The divorce decree didn't put the order of protection up. That's not what that's for. That's to separate the marriage, not for order of protection. That was already in place. She had already been removed from the marital home. The threat and harm was gone, the alleged threat and harm.
Well, I'm going to take a recess and review this
Yes,
authority
Judge.
that you have. But in asking this question, you would agree that the statute says that the division of assets or property in a marriage is to be done without regard to fault, correct?
Say that again, Your Honor.
That the court must make an equitable division of the marital property without regard to fault.
Yes, Judge.
All right. So that being the case, your client, if we maintain this case and it continues on, the only issue that's left in this case is division of property, correct?
That is the only issue, yes, Your Honor.
If I dismiss this on your motion, then you're going to be in the estate case, and in the estate case, what are you going to be litigating?
Well, I have a separate motion before Your Honor on that as well, objecting to the entry of the will.
But my point is that if you litigate the estate case, then under that, you're still going to be litigating the issue of who owns what property.
I can't answer that, Your Honor, because I have something pending before this court regarding the credibility of the will, so I can't answer that, Judge.
Well, I'm going to take a recess and I'll take a look at this case law that you've gotten, and I'll come back and give you my.
Thank you, Judge.
And if I could, I think the question that you ask is very pointed. And again, under Rule 54, once we do the property division, again, all matters can be appealed at that point in time. I don't disagree with that. But again, this case that she has pointed out is, and I think it's very, in reading it, that you have to look at it. It talks about, however, our courts have recognized one exception to the broad rule announced, wherein death terminates a divorce case. And it goes and incites in the Vessel versus Vessel case where the divorce had been heard, everything had been done, but he died before the time limit was up. Then it goes on to state, there's another possible exception in Tennessee that has been recognized by our courts in an unreported case. So the court in its dicta is saying it's not an absolute rule. Twice they have done it. And then it goes on to state that
Ms. Stevens, it's your motion. I'll give you the last word if you want to say anything else.
I didn't hear you. I'm sorry.
I'm sorry, it's your motion. You have the final say if you want to add anything to what you said.
Just reference exactly what I said before, Your Honor. It's not a favorable or less favorable. It's just the case law that I found that mirrors my client's position, and I want to bring that before your court.
All right.
Thank you, John.
Take a recess and come back and give you a moment.
All right.
All right, I'm back on the record in the Donald Howard Walker versus Elizabeth Diane Walker. And I want to make a few findings on the record before I tell you what I intend to do in this case. Number one, there was an order of protection that was filed in this case by Donald Walker. I believe looks like it was filed in July of 2023 in general sessions and then transferred to this court because of a pending divorce. And that petition for order of protection sets forth under oath the following grounds for the order of protection. Diane was mad and has been depressed. Diane told me she was going to and anyone affiliated with me. Number two, Diane told me she wanted me so that she could have all of our money. Number three, took the safe key that has guns and important paperwork. And I had my medication, hid my medication from me. Diane has a family history of mental illness, and it goes on as that. And an order of protection was then heard by this court on the 22nd day of January 2024 by me. And this court made the following findings. Upon the testimony of both the defendant, Elizabeth Diane Walker, and the plaintiff, Donald Howard Walker, exhibits presented and review of the pleading, the court finds that the defendant, Elizabeth Diane Walker, presents a credible to the plaintiff, Donald Howard Walker, and has made statements in the plaintiff's life. Further, from the proof offered, the plaintiff owned the home where the parties resided prior to their marriage, and due to several health issues, he should be awarded the exclusive possession. Additionally, the defendant, through her testimony, did not present sufficient evidence to establish a need for spousal support, nor did she establish that the plaintiff had an ability to pay. Then it went on to say that an order of protection would issue against the defendant, and she would not to abuse the plaintiff, the petitioner, Donald Howard Walker, not to stalk or threaten to stalk and so forth, and went on talking about all of the limitations as imposed under an order of protection. Then it went on in paragraph 2 of that order. It is ordered, adjudged, and decreed that based upon the sworn testimony of the respondent for admission found in sworn discovery responses, and the finding of the court that the plaintiff's current medical condition necessitates, the court awarded a judgment on the pleadings and grants an absolute divorce to the plaintiff on the grounds of inappropriate marital conduct of the defendant, and hereby restores both parties to all rights and privileges of unmarried persons. The issue of division of assets and other related matters is reserved pending a final hearing in this court. That was the order of the court that was entered. And then what I have before me is a motion to essentially vacate that order and dismiss this case based solely upon the fact that the plaintiff is now deceased. I have reviewed the McMahon versus Butler case that was cited. It is a 1986 decision of the Court of Appeal, and it is an unreported case as far as I can tell from this, and therefore unreported cases are not necessarily persuasive of the court or controlling for the court. They are instructive, but as was pointed out, there are several exceptions to this general rule about the death of a party in a divorce case being grounds for the dismissal of any temporary order. Number one, Rule 54 does provide, as has been quoted, that there is a provision for an order to be entered, but it also allows that upon an express direction of the entry of a judgment where there is no just reason for a delay, in the absence of such determination, direction, any order, that in any other form of decision, however designated, that adjudicate fewer than all claims or rights, liabilities of fewer than all the parties shall not terminate the action after any claims of the parties, and the order or other form of decision is subject to revision at any time for the entry of the judgment adjudicating all the claims, rights, and responsibilities of the parties, liabilities of the parties. So the question becomes, did this court's finding that the plaintiff's medical needs and the undisputed facts, or the court's finding of facts as to the basis for the granting of the divorce, where both parties sought a divorce, does that constitute a finding under Rule 54 as to there is no just reason for delay in express direction of the entry of a judgment? That would make it more of a final judgment on the issue of divorce rather than a interlocutory ruling. The court is of the opinion, too, that there is a need for further investigation as to the state of the law in the state of Tennessee, rather than, I don't dispute that the Stevens have produced this case, but I'm also not convinced that there might not be some other authorities. So I'm going to take this matter under advisement so that I can further investigate it and apply the law to these particular facts of this case. But I'm going to also allow both parties 30 days in which you may file any additional authority, research, authority, case law, or anything else. You'll have 30 days to file that with the court, and then thereafter I will make my ruling. Let's go ahead and set it for March 17th, just to say, so that I can announce my ruling rather than have to issue necessarily a written order, although I may do so.
March 17th.
March 17th is that's one of March 17th.
Thank you, Your Honor.
I'm not at all opposed to saying that it may be that this case is controlling, but I want to see if there's any more current law out there. Because Court of Appeals oftentimes changes their position on certain things, especially where it's an unreported case. So, thank you.
Your Honor, if we could, because there is, I think there's an issue, I would request, there's an estate matter pending, motion pending in the estate matter that should be held in abeyance pending this court.
Is that on the docket for today?
It is, Your Honor. There's a session that was filed in the claim for this direction.
The claim is by Elizabeth Diane Walker for a homestead exemption, elective chair, annual year spousal board, and attorney fees. And then there's also petition to contest the will.
I don't believe that's on your docket, Judge. Dang.
All that is.
Clearly, it would seem to me, as soon as I don't want to foreclose your argument, but it would seem to me that until I make a final ruling on
Yes,
the
sir.
motion, that that's premature to consider their exception to the claim.
Yes, Your Honor.
If I uphold her motion, then the claim may be verified and it may be sustainable. If I deny her motion, then it presents a different issue. So we'll take the matter off the docket and put it on the March 17th docket.
Thank you, Judge.
She wanted the divorce. First, I want to say that. She wanted the divorce, and the judge clarified that at the beginning. That was something that she wanted also. But he filed for divorce in 2023. In March of 2024, the divorce was granted, but they have a 60-day waiting period in Tennessee before it is finalized. 60 days is the minimum. It can go out longer if they are still discussing how they were going to split up property. And obviously, they continued to discuss that stuff when he passed away. Now, she wants the divorce tossed because she wants all the property. And, of course, she wants the will tossed because she knows she's not in the will. So, I'm anxious to find out how he's going to rule in March. I'd really like to hear that. So, I'm going to keep an eye on that. But, yeah, this one is a bit of a different one. You know, what do you do when one of the parties passes away before the divorce is finalized? So, that's the question, and that's basically what this is all about. Anyway, thank you guys so much for watching, and I'll see you next time.